us? Got a feel of the test? Got a feel of exam? Yes?
Yes,
I
sir.
Yes,
hope
sir.
there was no exception, right? Everybody had to write their test. Was there any exception to it?
No, sir.
No, sir.
Because suddenly I
Yes.
see only 26 participants. The rest 20 were not supposed to write, or how is it? Everybody has written, no? It was mandatory for everyone.
Yes, sir.
All right?
Yes, sir.
And that has
Yes,
been
sir.
conveyed by Shetty, sir. Clear?
Yes, sir.
All right, perfect. How was it? Good. It was good. It was bad, sir. Well, clear, sir. Not an issue. 40 barutte, sako. What else? Am I audible?
Yes.
Yes, sir.
Yes, sir.
Was it, guys? Because you've written a 100-marker paper. And for a change, I just went through your entire question paper as well as the answer script. There were a couple of blunders in the answers, all right, in the options.
Yes, sir.
Not sure how many of you bothered looking at it. Sir, we didn't observe because we know 1 out of those 4 have to be right. We have ticked and come back home thinking that it is right. I've seen there is one question in which all the 4 options were wrong. All right. Those of you who didn't bother, leave it. Anyway, I'm sure you might have skipped it. Anything else? Overall, good. How was the feel of it? How was the feel of writing those 2.5 hours, 3 hours of writing that test? How many of you were not able to complete the paper? Only one? I can't believe. I can't believe. 6 of you, only 6 of you? Out of 30, only 6 of you? Out of 31? If you do not buck up, you will have a problem. All right? Mute yourself. Everybody has to turn on the mute audio and video. There's no option. Whoever it was, unmute yourself and listen to me very carefully. I repeat, put on your hands. It's not just 8. I can bet on the fact there are at least 20 people sitting here who wouldn't have finished their paper. All right? Now, those of you who haven't finished your paper, biggest crime according to me. I'll tell you, you guys have done one of the biggest blunder. The reason being very simple. Sir, 3 hours were insufficient. Obviously, this is the question paper that you've just written isn't even up to the ICI mark. All right? There will be lengthier question paper than what you've just written today. Every day come what may, you're going to scribble 1 page before sleeping. Write whatever nonsense that you can think about, you have to write. Those of you who weren't able to finish the paper. Your wrist has to be absolutely flexible. All right? Only then you'll be able to pick up the pace. I'm not sure how many of you are able to make sense out of this statement. I repeat, not knowing anything in the answer script and not able to pass, chalega. Because you can at least show a face telling that I never prepared itself, boss. So I didn't clear. After preparing, not clearing the paper, because you couldn't finish the question paper itself, is a crime. Then what was the point of putting in so much efforts? Perfect. For those of you who haven't completed, trust me, it's the best thing that would have happened to you, because this is just giving you a hint. You have 1 month now, or rather 2 months now. Every day religiously, as long as you're eating food for the next 60 days, you have to ensure that you're going to write 1 page. And that 1 page has to be at a pace which you can understand. I would suggest pick any topic, randomly pick any topic from company law and keep scribbling. Write down, copy, paste, do whatever under the sky it makes sense to you. You have to write down. Keep increasing that day by day. Today it is 1 sheet. Tomorrow it is going to be 1 page. Day after tomorrow, 1 page, 1 sheet, 1. It has to be at least by the time you are sitting in September, your pace has to be picked up. Those of you who haven't written, can I know how much have you missed out not writing? Whatever it is. Anyway, you have not written. How much have you not written? I want to know that. Anybody who is not attempted for less than 80, who is attempted less than 80, raise your hands. Those of you who weren't able to complete the paper, and if you've attempted less than 80, raise your hands. That means you've left 20 marks.
Sir, I wasn't prepared much, sir.
That is not an answer. All right. My question is, those of you who weren't able to write the answer script fully, and you haven't written for more than 80, or rather you've written only less than 80, raise your hands. Only 2 people? 3, 4? Guys, now ask yourself. If you write for 100, getting 40 itself is a task. If you've written for 80, how will you get 40? 40 is not my aim. 40 is not my aim. But for you who have not completed the question paper, you have to sail through the paper, right? High time, please buck up. 2 months. Come what may, you have to write something every day and sleep. There cannot be a night without writing. I hope I'm loud and clear. Everyone understood? I repeat for the last time probably, not knowing the law is absolutely fine and not clearing is still justifiable. Knowing, putting in so much effort but not able to write the entire answer script is a crime. Clear, eh? Everyone understood? All right. Now let's go ahead. Please note, law is going to be your first theory paper in examination. After accounts, law is going to be your first paper. In accounts, you would have already got exhausted. Because the first paper, usually we get jitters. All right. We panic. We have all the possible emotions flowing through. In this situation, law will become trickier. So my suggestion to each one of you, ensure that your law is the strongest limb for you in the first group. Am I clear, everyone? All right. Make law your strength. You will be able to clear your first group. I know your entire syllabus is not divided into groups. Is it divided into groups? No, right? All right. So ensure that first accounts you will sail through. I am confident that you will clear accounts. Law is where people get stuck. You have to ensure that you spend time with this as if it's your girlfriend or boyfriend. Simple as that. All right. Now let's start with the evaluation. Chalega? Ready, eh? Everyone? Yes?
Yes, sir.
Yes,
Yes,
sir.
sir.
Tired after writing for 3 hours? You can't be. For those of you who thought I will say, oh, okay, I can understand. No, I can't. Because you can't be tired. Immediately after 2 months, you will have similar situation where you would have written an examination and you have to come back and read. There's no option. So those of you who are tired, keep telling yourself there's no option. You have to get tired, but still get through it. Simple, everyone. All right. Let's get started now. Let me know if the screen is visible to everyone. Yes. Everyone
Yes, sir.
can see the
Yes,
screen?
sir.
Perfect. Let's get started. All right. So what am I going to do is those theory question, all right, those MCQs, I will straight away jump into the answers. The first question is revolving around your CSR committee, all right, and unpaid dividend, rather unpaid dividend. Let's straight away jump into the answers. The first answer, start writing. All right. The first answer, A is the answer to the first question. All right. A is the answer to the first question. Second one, D is the second answer. All right. Third one, C is the answer. Fourth one, D is the answer. Fifth one, C is the answer. Sixth one, D is the answer. Seventh one, A is the answer. Eighth one, A is the answer. Ninth one, now let's go to the ninth one. Hold. All right. Ninth one, B is the answer. 10th one, B is the answer. 11th one, what have you written?
B.
Option B.
Option B. Why was it option B? Anyone? Why option B? Why option B? Why option B? Anyone? What is the question? Let's go back to the question. All right. I hope the screen is visible. I'll read out the question. Suppose Amit wants more money for his living cost abroad. All right. What is the maximum amount that can still be remitted? Please note they are asking for additional amount. All right. Not sure how many of you bothered reading that. For those of you who haven't read it carefully, please note total annual requirement was 55,000. He has already used 55,000. How much is the amount left there? All right. 55 plus 195 will make it 250 and LRS limit is 250. How many of you thought this question itself is wrong? Anyone sitting here? There are less options. There are wrong options. How many of you thought that? How many of you thought there is a mistake in the question? What was your thought process, by the way? That the limit should have been 250 was what should have been mentioned. You forgot to read the words still there. And congratulations, you are writing CA examination. All right. The only reason why I ask you to read the question carefully. Not sure how many. Did you guys understand the mistake, guys? Please
Yes.
be more than happy doing all possible mistakes now. I would appreciate making mistakes now, because this is just bringing us to get a flavor of the kind of questions. Circle the word still there and write down. Stupidity not considered in examination. All right, not allowed, not allowed. Clear, everyone? I hope rest of you have given 195. There's no option, huh? There's no option. Anybody has selected any other answer? Ask yourself, why would you do that? Because 55 he has already spent. 250 is the total limit. 250 minus 55 is the only answer there. There cannot be any other answer. All right, good. Next, 12 answer is B. 13 answer is B. 14 answer is D, D for dog. And 15 answer is D, D for dog. Everyone clear? How many of you have got 15, all the 15 correct?
Sir,
Anyone?
can you tell the answer for sixth question, sir?
Sixth one answer is D, D for dog. Don't ask me the logic, all right, because I have to spend some time on correcting your descriptive answers. How many of you have got all the 15 correct? How many of you got all the 15 correct? Not a single person has got all the 15 correct. We thought it's MCQ. Straight away 30 marks in our pocket. Look at it. Look at it. Realized everyone there in the session with me? Yes. How many of you have got 14 correct out of 15? Rather, instead of 15, how many of you got 14 correct? Only one person. Only one person was able to get 14 correct. How many of you have got more than 12 correct? So there's no option. 12 and 13 are the only option. How many of you got 12, 13 correct? Rest of you, what have you guys done? I don't know. MCQs weren't tricky at all. MCQs weren't tricky at all. If you missed out one or two, I'm okay with it. If you missed out the rest, not acceptable. Look at it. Everyone thought MCQ will be easy, crack, 30 marks in our hands. And this is where we have missed out. I'll tell you where have you guys missed out. Put on your hands, everyone. Priyadarshini. All right. Now, listen to me very carefully. 90% of you have done one mistake of assuming what the question could have been without reading it. If you've spent more than 30 minutes on these 30 marks, I think you've done a biggest blunder. How many of you were not able to finish all the 15 MCQs? Anyone sitting here who was not able to finish all the 15 MCQs, raise your hands. Right, wrong, don't bother. Just raise your hand. Anyone sitting here who is not able to finish all the 15 MCQs? You cannot do this mistake in examination. If anybody has done this, not affordable. Not affordable. If you realize each MCQ was of 2 marks here. One small mistake, gone, 2 marks at stake. One small mistake, gone. And if you realize, if you made 5 mistakes out of 30, you've already lost 10 marks. Making sense, everyone? All right. Please pay attention. Solve as many MCQs as possible. I'm not sure how many of you are aware. ICI, there is a one material only on MCQs. Everybody sitting here has to make it a point to go through the entire series of MCQ which is listed there. Am I clear, everyone? Am I clear? Sir, we are running short of time. I don't care. I don't care. This is not something that I'm telling you for the first time. Earlier also, I have made it clear to you guys, there is one material only on MCQs. I hope I'm clear. You still have time, 60 days. Make it sure that you put efforts and clear these MCQs. All right, let's go ahead. Now, let's go ahead with the next answer. All right, descriptive answers. Is the screen visible to everyone? Is the screen visible to everyone? I'll take all the questions maybe later on. I'll not take any of the questions now. Is that okay with you guys? All right. So let's go ahead and start with the descriptive question. One of you is going to quickly read the question without further delay. Start, one of you. Quick. One of you read the question.
ABC Limited is a registered public company having the following: directors and their relatives 20, employees 15, ex-employees shares were allotted during employment 20, members holding shares jointly 10 shares into 2 joint holders each, 20, other members 150. The Board of Directors of ABC Limited proposes to convert the company into private limited company, referring the provisions of the Companies Act 2013, advise whether the company can be converted into a private company, whether existing number of members need to be reduced for the proposed conversion into a private company.
Cakewalk this question is. By chance, anyone has missed out writing question number 1 itself because of lack of time? Anyone? Anyone who has done this mistake? Raise your hand if you have done this blunder. Anyone? None of you have done this mistake. If you've done this, slap yourself because question number 1 was compulsory. Now, what will happen in examination if I don't write a compulsory question? Trust me, I have no idea what will happen in your answer script if you don't write the compulsory question. I have no clue. I'm not sure if Shetty sir is also aware of what will happen in this situation, because there is a possibility I've heard a couple of people say they will not evaluate that answer script. There's a reason why it is tagged compulsory. I hope I am loud and clear, everyone. All right. 99.99% it will be question number 1, which is compulsory. If you are unlucky and if ICI wants to play around with you, they can make any other question also compulsory. So do not assume which is compulsory without reading the question paper. I'm telling you, 99%, it is always the question number 1. But you don't know when ICI wants to play around with students. It can make question number 4 compulsory. What will happen if you don't write compulsory question? No clue. I have no idea at all. I hope I'm clear. Everyone understood? Let's go ahead now. Simple cakewalk. This question is 5 marks. CA foundation question. If you ask me, this is not a CA inter question at all. How many of you have not written this in a pattern in the format? Provision of law, analysis, facts of the case, provision of law, analysis, conclusion. Anybody sitting here because of lack of time, have you missed out on the format? Anyone? Everybody has used the format, or what? Somehow difficult for me to digest. All right, nevertheless, let's go ahead. One of you read. All right, or rather, I'll only read the answer. If reference to section 2 clause 68 is given, give yourself 1 mark. Give yourself 1 mark. If reference to section 2 clause 68 is given, give yourself 1 mark. If you've just written 2 clause 68 without writing the Companies Act 2013, reduce 1 mark. I know there is no negative marking, but for God's sake, please do it. All right. How many of you have just written section 2 clause 68 without writing the name of the act? Anyone sitting here? Anyone sitting here? During our regular tests itself, I have made it clear you will not do this error come what may. I hope I'm clear, everyone. All right. So section 2 clause 68, if you've written, 1 mark. All right. Where you've written the maximum number of members will not exceed 200. All right. If you've written this, give yourself half mark. Half mark. 2 or more members holding the shares jointly shall for the purpose of this clause be treated as single member. Give yourself 1 mark if you've written this. The following shall not be included in the number of members. All right. Person who are in employment of the company, 1 mark. Person who have been formerly in the employment of company, where the members of the company while in the employment and have continued to be members after the employment ceased. If you've given this one, give yourself 1 mark. Clear, everyone? Understood? Finally, if you've given your answer 180, give yourself half mark. I'm not going to give you mark for the math. All right. I'm not giving you marks for math. Half mark. ABC Private Limited can go ahead and be converted into private limited. I'm not giving you marks for this. What is more important? Is there any requirement for reduction? All right. From the existing number of members, answer is no. There is no requirement. If you've written this, give yourself 1 mark. Let's go ahead with the next question. Quickly read the next question. Guys, you have to be very fast now. Start.
Mr. Ramachandra is a
Mr.
partner and in charge and certifies financial statements of A and Associates. The firm is appointed as an auditor firm of Badri Limited listed company. Mr. Ramachandra retires from A and Associates and after some time joined Gupta and Gupta firm as a partner on 25/24. In the general meeting of Badri Limited held on 15/6/24, the company appointed Gupta and Gupta firm as the auditor of the company. Advised Badri Limited whether the company has adhered to the provision of the Company Act 2013 by appointing Gupta and Gupta as auditor for the company.
straight question on rotation of auditors. All right. Simple straight question on rotation of auditors. Let's quickly get started. All right. Section 139, subsection 2, no listed company of the company or the company belonging to such class shall be appointed or reappointed an individual for more than one term of 5 years and an audit firm for more than two consecutive terms of 5 years each. If you've written this, give yourself 1 mark. If you've written this, give yourself 1 mark. As is. Section 139(2 rather. Individual auditors, 1 term of 5 years, and audit firm, 2 terms of 5 years. If you've written this entirely, then give yourself 1 mark, or else do not give even half mark. Or else do not give even half mark. Sir, is it being too strict? Answer is yes. All right. I don't want you guys to get 100 on 100 now and then think that you know entire law. Stupidity is not required right now. I can't afford it. All right. Next, provided that an individual who has already completed a tenure shall not be eligible for reappointment in the same company for 5 years. An auditor firm which has already finished the term in clause B shall not be eligible for reappointment after the tenure of in the same company for 5 years from the completion of such tenure. Provided further that no audit firm having a common partner to that of the other audit firm whose tenure has expired preceding the financial year shall be appointed as the auditor of the same company for a period of 5 years. If you've written this proviso, give yourself 2 marks. If you've written this proviso as is, give yourself 2 marks. If you've used the word common partners, at least give yourself 1 mark. All right. Now, going to the answer. If a partner who in charge of an audit firm and also certifies the financial statement retires from the said firm and joins another audit firm, such other firm also shall not be eligible to become an auditor for 5 years. If you've written this, 2 marks. Rather, give yourself 1 mark. I'm sorry, give one mark because I've already allotted there. Final conclusion. As per the facts of the case, Gupta and Gupta firm will not be eligible to be appointed as an auditor of Badri Limited for a period of 5 years. If you've written this, 1 mark. Simple. Let's go ahead. Next question.
Analyze the below mentioned situation in the light of provisions of the Foreign Exchange Management Act 1999. 1. Mr. Vinod has won a big lottery and wants to remit $20,000 out of his winnings to his son who is in Singapore. Second one, Mr. Sham requires $5,000 for remittance towards hiring charges of transponders.
All right. Simple questions these are. If you remember, we have discussed these during our regular sessions also. All right. Let's go ahead and discuss this in detail. I hope the screen is visible to everyone. All right. Section 5 talks about current account transaction. All right. If you've given reference to Section 5 of the FEMA Act 1999, give yourself 1 mark. Give yourself 1 mark. Let's go ahead. All right. Give yourself 1 mark. As per the rules of FEMA, current account transactions are categorized under 3 buckets, where withdrawal of forex is prohibited, where it is permitted with the appropriate approval from the government, all right, and where it is allowed provided RBI's approval is there. If you've written these 3 points, give yourself 1 mark. All the 3 points. Sir, if I missed out one and if I'm not written one, all that nonsense, don't give yourself mark. I am not going to be liberal here. Please note. Next, can Vinod go ahead and withdraw? Answer is no, he is prohibited. If you've used the word prohibited, only then give yourself 1 mark, or else do not give yourself 1 mark. If you've used the word prohibited, only then give yourself 1 mark. I hope everybody sitting here has used the word prohibited, because I've discussed this, giving example and lame, stupid examples though, but I remember giving this in detail discussed. Second thing, can he go ahead and use the money for remittance of higher charges of transponders? Answer is yes, with the prior approval of central government. If you've given this, 1 mark. How many of you have got 4 on 4 here? Anyone who's got 4 and 4? FEMA is easy, no? All right. Just 2 or 3 of you have got 4 on 4. Please note. Put down your hands, everyone. Please note. FEMA efforts required. FEMA efforts required. How many of you have got all the three answers correct. All right. So effectively, we are talking about 14 marks. How many of you have got 14 on 14? How many of you have got 14 on 14? Not a single person. Not a single person. All right. Let's go ahead. Next with the question. I'm okay. I'm okay with it. As long as you circle all the mistakes. I hope you're using a red pen to circle the mistakes, everyone. All right, let's religiously be a student and continue being for a while. Let's go ahead and read the next question. Quick!
Mr.
Referring
Romit,
to the provisions of the Companies Act 2013, decide whether the amount received from Mr. Romit will be considered as deposit as per Rule 2(1)(c).
Brilliant,
Romit-
Vishruta. Please note, first thing, you will read the question the way we have learned it. Please do not deviate. All right, last sentence first, then read the entire question. Simple as that. Go ahead. Majority of you
Romit-
have not done this, I can bet on the fact majority of you wouldn't have done this. This is exactly where you missed out as well. You will realize over a period of time. Go ahead.
Mr. Romit is an employee of PQR Trading Private Limited. As per his contract of employment, his annual salary is 5 lakh. Mr. Romit paid the company 5,30,000 in the nature of non-interest bearing security deposit. Referring to the provisions of Companies Act 2013, decide whether this amount received from Mr. Romit will be considered as deposit as per Rule 2(1)(c).
First thing, if you have written Rule 2(1)(c), you will not get any marks. It is given in the question itself. Relax. All right. Stop getting excited. Oh, I've written. All right. Now coming to the point, what will not be considered as deposit? As per Rule 2(1)(c), any amount which is received from an employee not exceeding his annual salary under a contract of employment will not be considered as a deposit. If you've written this as is, give yourself 2 marks. Give yourself 2 marks. Give yourself 2 marks. Annual salary is the key there. Annual salary is the key there. I hope I'm clear, everyone. Understood? Next. In the instant case, 5,30,000 was given. However, his annual salary is 5 lakhs. So based on this, the amount received from Romit more than his salary, so it will be considered as deposit. Now, first point, if you've written entire 5,30,000 will be considered as deposit, only then give yourself 3 marks or else no marks to be allotted. How many of you have done the blunder of considering 30,000 as deposit? Anyone sitting here who has considered 30,000 as deposit and you've made the statement as well? None of you. I know my students, all right? None of you, not a single person has done this blunder or what? I know my students, all right? Put down your hands. Put down your hands. Please note, entire amount will be considered as deposit until and unless you put 5,30,000 entirely, all right? You will not get marks. Consider if you've written entire 5,30,000 will be considered as a deposit, only then give yourself 3 marks. Sir, are you being unrealistic while scoring? No. I am being absolutely realistic. I have the answer scripts. I'll show it to you. For writing one word, they've given 3 marks in examinations. I will show it to you. All right. Because they are not looking for your fancy English there. They're looking for the main crux of the law. I hope I'm loud and clear. Everyone there in the session with me? All right. 3 marks if you've written 5,30,000. Entire amount to be considered as deposit. Let's go ahead. Next point. Next question. Quick.
Mr. Kaushal is a chartered and an MBA by profession, has been appointed as an executive director on the board of XYZ Limited. His job profile includes advising the board of directors of the company on various compliance matters, strategies, business plans, and risk matters relating to the company, keeping in a wave of above position whether Mr. Kaushal can be classified as the promoter of XYZ Limited. Examine the same under the provisions of the Companies Act 2013.
Where have we come across this definition of promoter? If you remember, we've discussed this during prospectus and incorporation, both the places. Prospectus, primarily, I had discussed who's a promoter. All right, let's go ahead. If you've written the definition of promoter as is, give yourself 3 marks. All right. Section 2, clause 69 defines a promoter. Promoter means a person whose name has been mentioned in the prospectus as is or who has been identified in the company in its annual return. Second, who has control over the affairs of the company directly or indirectly, whether as a shareholder, director, or otherwise, or in accordance with whose directions or instructions the board of directors are provided or are accustomed to act. If you've written all the 3 points, then give yourself 3 marks. If you've written all the 3 points, only then give yourself 3 marks. How many of you have not written the section number in this? Section 2, clause 69. Reduce -1, -1, -1. Important section. I started prospectus with this section. Next point. Proviso. Nothing in subclause C shall apply to somebody who is doing it in his professional capacity. If you've written this proviso, then give yourself 1 mark. Professional capacity is not going to be considered under the promoter definition. Last answer. Mr. Kaushal is only limited to advise the board of directors, all right, which is done as a part of his professional capacity. Therefore, he is not classified as a promoter, all right. If you've written he is not to be classified as a promoter, give yourself 1 mark. Let's continue. Everyone there in the session? Let's go ahead. Next question.
Define the following with reference to the provisions of the General Clauses Act 1897. First one, measurement of distances. Second one, duty to be taken pro rata in NR.
4 marks. Easy cakewalk. All right. If you've written section 11 of General Clauses Act, give yourself 1 mark. If you've written General Clauses Act, section 11, give yourself 1 mark. How many of you have not written section 11? I want to see those faces. How many of you have not written section 11? Raise your hand. Quick. How many of you have not written? General Clauses Act. 3 chapters of other laws. I've told you guys, please ensure you know word by word. We cannot afford making mistake here. Put down your hands. Everyone, easy way to remember, might be stupid, but I want you to remember. All right. Measuring this distance is covered under section 11. Let's go ahead. Section 11 talks about measurement of distance. If you've written straight line on a horizontal plane, give yourself 1 mark. Give yourself 1 mark. As is straight line on a horizontal plane. Sir, this I've written, that I've written, anything missing in this phrase, don't give yourself mark. Simple as that. Don't ask me about the alternatives here. Straight line on a horizontal plane. If you've written this as is, give yourself 1 mark. Clear? Let's go ahead. Next. Duty for taken pro rata in enactments. All right. Whereby any enactment now in force or hereinafter, any duty, custom or excise is in the nature or in the nature thereof, is leviable on given quantity by weight, measure or value of any goods, then like duty is leviable according to the same rate on any greater or less quantity. What is the meaning of this? 10% is your tax on income. Your income is 10 lakh rupees. How much is the tax you pay?
1 lakh.
1 lakh.
Any confusion? Your income is 1 crore. How much is the tax you pay?
10.
10 lakh.
What is this? As much as the quantity is there, comparative, your proportionate rate has to be applied. That's what this law is talking about. Something really high funda. I don't really think so. All right. If you've written, all right, duty is leviable according to the same rate on any greater or less quantity, give yourself 2 marks. Simple as that. Simple as that. Understood? Can I continue? All right. Can I continue? Everyone there in the session? Next. Simple question. The next one is nobody can do a blunder here. Read. Read, one of you.
Trinity School started imparting education on 1st April 2010 with the sole objective of providing education to children of weaker society, either free of cost or at a very nominal fee, depending upon the financial condition of their parents. However, on 30th March 2024, it came to the knowledge of central government that the said school was operating by violating the objects of its objective clause, due to which it was granted the status of a Section 8 company under the Companies Act 2013. Describe what powers can be exercised by the central government against the Trinity School in such a case.
CA Foundation, we have learned this. At CA Inter, we have learned this. All right. Initial chapter itself, when I was discussing about a Section 8 company, all right, types of company, Section 8 company, I've told you what will happen in case if you don't follow the objective. You cannot declare dividend. If you do so, your license will be revoked. All that we had discussed, if you recall. All right. Let's go ahead and answer this question. I hope the screen is visible to everyone. All right. Section 8 of the Companies Act deals with the promotion or formation of a company which are formed for the purpose of charitable objects of commerce, arts, science, etc. All right. Since Trinity School was a Section 8 company and it has violated its object clause, the central government can go ahead and exercise the following powers. You will not get marks for whatever I've just read now. There is no marks for that. What I will read now, you will get marks only for that. All right. Because what is written as an introductory paragraph is coming from the question itself. You haven't invented anything there. Central government may by order revoke the license of the company. If you've used the word revoke the license of the company, give yourself 1.5 mark. Can I continue? Where the company contravenes any of the requirements or the conditions of this section subject to which a license is issued, or where the affairs of the company are fraudulently conducted or violative to the objects of the company which are prejudicial to the interest of public, or and on revocation of the registrar, shall put limited or private limited against the company's name. If you've written this, give yourself 1 mark. Give yourself 1 mark. You will have to start using the word limited and private limited against your name. Next, central government, but before doing so, will give a notice and an opportunity of being heard. If you've written this notice and opportunity of being heard, give yourself 1.5 mark. Next point, where the license is revoked and it is satisfied that it is essential in the public interest that the company registered under should be amalgamated with another company which is registered under this section having similar objective, then the central government may by an order provide for such amalgamation to form a single company with such constitution, powers, rights, etc. In simple terms, if you mention company shall amalgamate with another company with similar object, give yourself 1 mark. Give yourself 1 mark. Let's go ahead with the next question. Read, quick.
A general meeting of ABC Private Limited
Boring,
was
guys.
scheduled to
Sleepy.
be held on.
Hold. There in the session, everyone. All right.
Yes,
Are
yes,
you
sir.
losing
Yes, sir.
confidence by any chance? I'm scared of that one limp. Are you guys losing your confidence? Able to sail through? Let's make mistakes. That's absolutely fine. I don't want you guys to get 100 on 100. Even if you've just got 30, more than enough. Because the evaluation which I'm doing right now is extremely strict. All right. Don't get carried away. Even if you get 30, more than enough. But please make note of your mistakes or else this entire exercise is futile. All right. Go ahead. Read.
A general meeting of ABC Private Limited was scheduled to be held on 15th April 2024 at 3 p.m. As per the notice, the members who will be unable to attend the meeting in person can appoint a proxy, and the proxy forms duly filled should be sent to the company so that the company can receive it within time. Mr. X, a member of the company, appoints Mr. Y as his proxy, and the proxy form dated 10/4/2024 was deposited by Mr. Y with the company as its registered office on 11/4/2024. Similarly, another member, Mr. W, also gives 2 separate proxies to 2 individuals named Mr. M and Mr. N in the case of Mr. M, the proxy dated 12/4/2024 was deposited with the company on the same day, and the proxy form in favor of Mr. N was deposited on 4th April 2024. All the proxies via Y, M, and Z were present before the meeting. According to the provisions of Companies Act 2013, who would be the persons allowed to represent as proxies for member X and W respectively?
Let's go ahead and answer this question. If you've given reference to section 105, give yourself 1 mark. If you've given reference to section 105, give yourself 1 mark. All right. Proxy due date. All right. If you mention that it has to be submitted 48 hours prior to the meeting, give yourself 1 mark. A member can appoint only 1 proxy for the same meeting. If you've written this, give yourself 1 mark. If multiple proxies are appointed, listen to me very carefully. Proxy received last within 48 hours is considered valid. All right. If there are multiple proxies, then whoever proxy finally latest one which I've got which is within 48 hours, will be considered as valid, or else there is the first one itself will continue. In this scenario, all right, Y is a valid proxy for Mr. X. Y is a valid proxy for Mr. X. If you've written this, give yourself half mark. There's nothing here. It's a straight point here. All right. Where is the confusion? The confusion is next. W is appointing M and N both as proxies. M was appointed on 12th. N was appointed on 14th. When is the meeting? Meeting is scheduled on 15th at 4 p.m. All right. Was the second appointment within time? Answer is no, it was not within 48 hours. All right. So only one appointment, which is the appointment? M appointment. All right. Whoever was M, his appointment will stand valid. All right. Appointment of Mr. M will stand valid. Why not N, sir? N is because 48 hours were not elapsed. I was very clear. I will give you only 48 hours and nothing more than that. Am I clear, everyone? Understood? Yes. Crystal clear. Can I continue? Yes. If you've written N has been a valid appointment because M is a valid appointment because N was not appointed within 48 hours. If you've written this, give yourself 1.5 mark. Let's continue with the next question.
Explain the doctrine of contemporaneous exposition.
All right. Stay it away, contemporaneous expositio. Simple point. All right. What is this? The doctrine is based on the concept that a statute is to be interpreted by referring to the exposition it has received from the contemporary authority. If you've used the same language, give yourself 1.5 marks. Simple, nothing high funda. All right. Next. This means a law should be understood in the sense in which it was understood at the time when it was passed. If you've written this, give yourself 2 marks. 2 marks if you've written this. Annapurna there? Yes? It should be understood in the same sense in which it was understood at the time when it was passed. This maxim is to be applied for construing ancient statutes, but not to acts that are contemporarily modern. If you've written this, give yourself 1 mark. Nothing high funda. What are we trying to say? If it is applicable to the old laws. If something is passed today, then anyways you will see what is happening today. There is nothing called as understanding what is happening around today. What nonsense. What is it applicable? It is applicable to the old laws where you have to go back and understand what was the situation at that point of time and have to give the meaning accordingly. Clear with the point? Everyone understood? All right. Next. That's it. There's nothing in this contemporaneous exposition. Nothing is there. Next question.
Manoj Limited declared a final dividend to its shareholders at the annual general meeting on 1st August 2024. As per the decision, the dividend payment was to be made within the stipulated 30-day period. However, due to internal financial constraints, the company failed to pay the declared dividend and did not dispatch the dividend warrants to the shareholders within the required time frame. The default continued until 15th October 2024, leading to the shareholders' complaints. In light of this scenario, what specific punishments and liabilities could the company and the directors face due to the failure to the payment to pay the declared dividend within the 30-day period? Give your answer as per the provisions of the Companies Act 2013.
While we were doing a revision session, I'd spent extra 5 minutes only on this slide, where I told 18% has to be given as interest. All right. If you do not go ahead and give the dividend on time, let's go ahead and read the answer. 5-marker question. How many of you have gone ahead and written 12%? How many of you have written 12%? Anyone sitting here who has written 12%? I know my students are there. I know my students well. All right. Your exercise after the session is you're going to make a small message for each one of your friends and tell what is the difference. When is this 12% going to come? When is 18% come? You will do this exercise and circulate it amongst your friends. I hope I'm clear. Everyone understood? Both of you. Both of you. I hope I'm clear. And again, I am betting on the fact the moment you do this exercise, you will not forget in your own examination. Whether others remember or not, I don't care. You both will remember. Clear, everyone? Understood? All right. Be more than happy making mistakes now. It's affordable. It's affordable. Let's go ahead. Read the answer now. Start. Section 127. In case of a company fails If you have given reference to section 127, give yourself 1 mark. Give yourself 1 mark. "30 days of declaration is the time period." I know this is there in the question paper, but still I want you to reiterate this. Give yourself 1 mark if you have not written 30 days. All right. I know it is there in the question, but I have to clearly mention that 30 days is what law has given me to make the payment. Am I clear, everyone there in the session? All right. Within 30 days, if the company fails to pay the dividend, then following punishments will arise. Director shall be punishable with an imprisonment of up to 2 years, and he shall also be liable with a fine of rupees 1,000 per day during which the failure continues. All right, 2 marks for this. 2 marks for this. Company shall be liable with an interest of 18% per annum during the period for which the default continues. If you've not written during the period for which the default continues, give yourself only half mark. 18% per annum for what? When should I calculate this? How long should I calculate this? How many of you have just written 18%? How many of you have just written 18%? We thought writing 18% will get marks. All right. From when? Date of incorporation till the date of payment. How long is this interest to be paid? We thought we'll get 1 mark. Complete answers are here. All right. Put down your hands. Now, all these friends, all right, one of you take up the initiative and circulate amongst your friends what is the error that you've done, and you will not repeat. Guys, please do it. Do it. Trust me. You will remember me for only this one aspect at least. I am certain about this. We have done all of this. It worked. Next question. Next question. Next question. Quick.
Define the term small limited
liability partnership as per the provisions of Limited Liability Partnership Act 2000.
When I was doing our revision session itself, I told you, small LLP is an amendment. It's an important topic. But I'm still telling you, though this question is 5 marks, very few of you will get 5 on 5, even here. Even though I'd mentioned that this is important, very few of you will get 5 on 5. Let's get started now. All right. Section 2, clause 1 TA. If you've written this, give yourself 1 mark. Give yourself 1 mark. How many of you have not written section 2, clause 1 TA? You've just written section 2, clause 1. You've not written TA. Even after highlighting it is important, how can we do a mistake of this sort? I don't know. All right, put down your hands. Put down your hands. Guys, please pick up. LLP. Contribution does not exceed 25 lakhs, half mark. Or such higher amount not exceeding 5 crore rupees, half mark. If you've not written 5 crore rupees, slap yourself. Quickly, how many of you have not written 5 crores? How many of you have not written 5 crores here? Everybody has written, or what? All right. And if you've written this word and, give yourself 1 mark. You should know the history of this word and. I have discussed in length. Not just that. After this and, have you written or? Ask yourself, check. Have you written and or both? Only then give yourself 1 mark. If you've just written and, wait, everyone. You have to write and in the first condition, and after the second condition, you have to write or. How many of you have not written any of these? Raise your hands, quick. Buck up. One of you are going to take up the initiative amongst this group and circulate amongst your friends. First condition is and, second condition is or. Why? Because the third condition, which has been prescribed, has not been stipulated by government as of now. There are only 2 conditions. That's why I have an and between them. And the third condition has not been enforced. That's why I have an or between them. Able to understand, everyone? And this was also something that I had discussed during our own revision session. Anyway, second point, turnover 40 lakhs. Do not give marks for this. Wait. As per where are you going to check this turnover of 40 lakhs? If you have written statement of accounts and solvency, only then give half mark, or else you will not get half mark. Next. not exceeding 50 crore rupees. All right. If you've written this, give yourself half mark. Clear, everyone? One last point, which I don't want anyone to miss out in their examination. Such other requirements as may be prescribed. If you've not written this, -1. If you've written this, only then give yourself 1 mark. How many of you have not written the third condition? How many of you have not written the third condition? Quick, quick, quick. Guys, please note, while I was discussing your LLP, I had clearly mentioned there's a small difference between small company and small LLP. And the difference is this third condition and the or before this third condition. If you remember, everyone there in the session, understanding? Circle, circle, circle. Absolutely fine. Make mistakes. Let's learn from here. Next, let's go ahead with the next question. Guys, quick, we are running short of time.
What are the difference between the interpretation and construction in the legal context, and how do these two concepts
relate to each other as per interpretation of statute? All right. First thing, they are interchangeably used to denote a process adopted by the courts to ascertain meaning of the legislature from the words with which it is expressed. All right. If you've written this interchangeably to be used, all right, interchangeably used, give yourself 1 mark. Quick. Give yourself 1 mark. Interpretation is an art of ascertaining the meaning of words and true sense in which the author intended that they should be understood. It's an art of ascertaining the meaning of true words or of the words. If you've written this, give yourself 1 mark. The court adheres to plain meaning of the language used by the law. It would be interpretation. Give yourself 1 mark. Court has to decide whether the wordings was meant to cover the situation before the court. All right. It will be considered as construction. If you've written this, give yourself 1 mark. Conclusions drawn by means of constructions are within the spirit, though not necessarily within the letter of law. If you've written this language, 1 mark. Nothing. Simple. Let's go ahead with the next question. Quick.
Ravi and Neha, two entrepreneurs, plans to start a new limited liability partnership LLP focused on AI-based software development. They decided to name their LLP as Next Gen AI Innovation LLP. Before proceeding with the incorporation, they want to ensure that their chosen name is available and reserved. They apply to the registrar through the prescribed web-based platform and pay the required fee for name reservation. Describe the legal requirement as to the reservation of a name as per relevant provisions under LLP Act 2000.
5 marks. All right. Giving reference to section 16, 1 mark. Quick. Section 16, 1 mark. Can I continue? Everyone there in the session? Reservation first. The name in a person may apply for the registrar for reservation of name in either of the following circumstances: as the name of the proposed LLP or as the name to which an existing LLP proposes to change its name. The application must be made in a prescribed form and the manner along with the prescribed form. Upon receiving the application, the registrar may, if satisfied, the name is not liable to be rejected under section 15 of subsection 2, reserve the name for a period of 3 months from the date of intimation by the registrar. If you've written 3 months from the date of 3 months from the date of intimation to the registrar, give yourself 2 marks. 2 marks. The name should not be undesirable, 1 mark. The name should not be identical or too nearly resembling that of any other LLP or a company or registered trademark of any other person under the Trademark Act 1999, 1 mark. If we've written these two as is. Clear, everyone? Can I continue? Yes. Next question. Vishal Limited is an unlisted company, has been directed by the central government to prepare periodical financial results and undergo a limited review. The board of directors is objecting, arguing that it is an unlisted company. They are not required to prepare periodical results. Analyze this situation with reference to the relevant provisions of Companies Act. While I was discussing this, I told you it's an amendment. It is an important section. All right, section 129A is an important section. If you have given reference to section 129A, give yourself 1 mark. Give yourself 1 mark. The central government may require such class or classes of unlisted company. If you've used this word, such class or classes of unlisted company, give yourself 1 mark. Prepare the financial statement on periodical basis, obtain approval from the of the board of directors, and complete audit or limited review of such financial statement. If you've written these 2 points, give yourself 1 mark each. File a copy with the registrar within 30 days of completion of the relevant period. If you've given this, give yourself 1 mark. If you've given this, give yourself 1 mark. Vishal Limited is not correct. Is not correct. If you've written this, give yourself 1 mark. Vishal Limited is not correct. If you've given this, 1 mark. Next question. Quickly read, one of you. Start.
In
Quick.
2020,
Has
the
to be
central
faster.
government enacted the Digital Communication Act to regulate and manage digital communication across the country. The Act provides specific duties and responsibilities for the director and digital communication, including the oversight of digital infrastructure, enforcement of regulations, and ensuring compliance with the data protection standards. In 2023, the Director of Digital Communications, Mr. Rajan Patel, was appointed to lead the implementation of this Act. However, in January 2024, Mr. Patel took a medical leave of absence for
During his absence, Ms. Priya, the Deputy Director of Digital Communication, was lawfully assigned to perform the duties of the director. While Mr. Patel was on leave, major data breach occurred involving a significant violation of the data communication. Ms. Sharma took immediate action to investigate the breach, enforce penalties, and implement new compliance measures to prevent the future incident. The actions by Ms. Sharma while performing the duties of the director led to a legal challenge. The opposing party argued that only the director, as specified in the Act, had the authority to enforce such penalty, and Ms. Sharma's action were invalid. Analyze the validity of Ms. Sharma's action in the context of General Clauses Act 1897, considering the provisions of official chiefs and subordinates. Guys, what is this? Official chiefs and subordinates, the law is very simple. What is applicable to the official chief is applicable even to their subordinates. What your parents have to follow, even you have to follow. As simple as that. All right. What your senior in office has to follow, even you have to follow that. It can't be different. All right. And in the absence of your senior, you will be equally responsible for the duties of your senior. Simple as that. All right. Now, according to Section 19, a law relative to a chief or superior of an office shall apply to the deputies or subordinates lawfully performing the duties of that office in the place of their superior to prescribe the duties of the superior. If you've given this, 2 marks. If you've written this, 2 marks. In the instant case, Ms. Priya was the deputy director, was lawfully assigned to perform the duties of director. Hence, the action taken by Ms. Priya were valid. If you've written this, 2 marks. Let's go ahead with the next question. Quick.
Examine the validity of the following decisions of the Board of Directors with reference to the provisions of the Companies Act 2013. In an annual general meeting of a company having share capital, 80 members present in person or by proxy holding more than 1/10 of the total voting power demanded for poll. The chairman of the meeting rejected the request on the ground that only the members present in person can demand for poll.
Now, what is this Section 109? If you've given reference to Section 109, give yourself 1 mark. If you've given reference to Section 109, give yourself 1 mark. Demand of the poll or before or on the declaration of the result of the voting on any resolution on show of hand. Accordingly, law says that before or on the declaration of the result of voting on any resolution on show of hands, a poll may be ordered to be taken by the chairman on his own motion or based on a request. Who can request in case of a company having share capital by members present in the person or by proxies were allowed and having not less than 1/10 of the total voting power or holding shares on which an aggregate sum of not less than 5 lakh rupees or such higher amount as may be prescribed has been paid up. And in case of any other company by a person holding not less than 1/10 of the total voting power. If you've written both these conditions, give yourself 2 marks each. If you've written both these conditions, 2 marks each. In this case, 80 members were present who were representing more than 1/10 of the total voting power. Hence, the contention of the chairman is not valid. If you've written this, 1 mark. If you've written this, 1 mark. Let's go ahead with the next question.
Mr. Prakash purchased a commercial property in Mumbai belonging to PQR Limited after entering into an agreement with the company. At the time of registration, Mr. Prakash came to know that the title deed of the company was not free, and the company expressed its inability to get the title deed transferred in Prakash's name, containing that he ought to have the knowledge or charge created on the property of the company in line with the provisions of Companies Act 2013. Advise whether the contention of PQR Limited is correct.
All right. If you've given reference to Section 80, give yourself 1 mark. It's a public notice. All right. any person acquiring such property undertaking shall be deemed to have the notice of the charge from the date of such registration. If you've written this, give yourself 2 marks. 2 marks. All right. Any person acquiring such property assets undertaking shall be deemed to have the notice of such charge from the date of registration. 2 marks. 80 clarifies that if any person acquires any property in respect of which a charge is already created, it would be deemed that he has a complete knowledge of the charge from the date of registration. Mr. Prakash therefore ought to have been careful while purchasing the property and should have verified beforehand that PQR Limited had already created a charge. In view of the above, contention of the company PQR Limited is correct. If you've written this, give yourself 2 marks. 2 marks. Let's go ahead. Next question. Quick.
XYZ Limited, a company incorporated outside India,
Is it
and to
visible?
which, yes, sir, and to which provisions of the chapter of the Companies Act 2013 are applicable, entered into a contract with ABC Limited, an Indian company, for the supply of machinery. After the machinery was delivered, ABC Limited failed to make the payment, citing defects in the machinery. XYZ Limited discovered that it had failed to comply with certain provisions of the chapter of the Companies Act 2013 relating to the registration of foreign companies in India. Despite this, XYZ Limited intends to file a suit against ABC Limited for payment. Discuss whether XYZ Limited can initiate legal proceedings against ABC Limited in the light of the non-compliance with chapter of the Companies Act 2013. Give your answer as per the provision of the Companies Act 2013, read along with the company's registration of foreign company rules 2014.
Guys, this is one of the simplest question in your entire question paper. All right. Why? Because this was something I had discussed while I was discussing companies incorporated outside India, where I've told you, because there is a defect, just because I'm not following Companies Act does not mean that I will lose the right to file a case, and I will still go ahead and continue contracting with you under the Indian Contract Act. All right. This was something that I discussed. Let us go ahead and read the section. Section 399 and 393. Any failure by a company to comply with the provisions of Chapter 22 shall not affect the validity of any contract, dealing, or transactions entered into by the company or its liability to sue thereof, to be sued thereof. If you've written this, give yourself 2 marks. Shall not affect the validity of any contracts. Shall not affect any liability. Shall not affect the validity of any contract. 2 marks. Company shall not be entitled to bring any suit, claim, or institute any legal proceeding in respect of such contracts until the company has complied with 2013. If you've written this, 1 mark. In this question, XYZ Limited, incorporated outside India, has not complied with Chapter 22, which governs the registration and compliance of for the foreign companies operating in India. All right. Non-compliance with Chapter 22 does not affect the validity of the contract. Therefore, contract between XYZ and ABC remains valid. If you've written this, give yourself 2 marks. For XYZ cannot bring a suit until and unless it starts complying with the provisions of Chapter 22. If you've written this, 1 mark. If you've written this, 1 mark. The last question. All right. Every sitting here should have answered this, because during revision itself, I discussed this in length. Read, one of you.
Miss Pearl was an Indian citizen who got a job in a software company in USA. She went to USA and stayed there for 15 years. During her stay, she purchased a house in USA for her residence. Then, due to some personal issues, she moved back to India and joined a software company in India. As she had moved back to India, she let out her house in USA and deposited the obtained rent in her account in USA. Advise whether Ms. Pearl can purchase another house in USA from her account in USA. Give your answer referring to the provisions of the Foreign Exchange Management Act 1999.
Section 6, subsections 4 of the FEMA. A person resident in India may hold, own, transfer, or invest in foreign currency, foreign property, or any immovable property outside India if such security property was acquired, held, or owned by any such person when he was a resident outside India, or inherited from a person who has been resident outside India. This was something that I discussed during our revision session as well. I'd categorically mentioned this is important. You cannot hold foreign currency, foreign properties, exception if I've inherited it or if I've owned it even before becoming a resident in India. In that case, nobody can stop. All right. If you have written section 6 to this entire point, give yourself 3 marks. Give yourself 3 marks. Give yourself 3 marks. Pearl, during her stay in USA, purchased a house in USA. As per the provisions of and facts of the case, Miss Pearl can purchase a new house in USA from her USA account. Is it allowed? Yes. 1 mark. 1 mark. Quickly giving you 30 seconds. Total up. Total up. Total up. Quick, 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 quick. Write down the total in the bottom of the page. Huh? Guys, is it okay if I can take another 5 minutes? Is that okay with you guys? Yes?
Yes, sir.
Yes, sir.
Go ahead, Srinivas.
Sir, can you please show that MCQ answers, sir?
MCQ answers. Once you're done, let me know. Total? Everyone?
Okay, sir.
Total? Yes, no, respond.
Yes, sir.
Yes, sir.
Yes, sir.
Yes?
Sir, done. Thank you.
Done? Totaled, everyone?
Yes, sir.
Quick. How many of you have got more than 70? Anyone sitting here? More than 70? More than 70, not 17, huh? 70. 3 of you have got more than 70. I want you to do a quick exercise for yourself. Chapter wise, you're going to mention where have you lost marks. Chapter wise, you're going to do this exercise. And if coincidentally, all 3 of you, after the session, you're going to do this tomorrow itself, you are going to find out, discuss amongst 3 of you at least, and tell what is that common chapter where 3 of you, all 3 of you have missed out. I repeat, I'm not sure how many of you have understood. If the question is from FEMA, all 3 of you have missed out. All right, all 3 of you have not got enough marks there. Total up all the FEMA chapter, total up. Overall, from FEMA chapter, let's suppose there were 10 marks. All 3 of you have got less than 20% in that chapter. You're going to come up with your points that I am losing out here. You're going to communicate it amongst all the 30, 50 of you to give extra focus on that chapter. Am I clear? Everyone making sense? Because I'm not taking 1 person mark. There's a possibility that 1 person might not have studied that 1 chapter. But 3 of you doing the same mistake might be very less as a chance. How many of you have got more than 60? Raise your hand. These 3, put down your hands. More than 60. Priyadarshini, put down your hand. More than 60. Others? I fear is with the others. All right. Madhuri, same exercise. Chapter wise, you're going to run through this entire thing. Chapter wise, you're going to decide where have you lost. If it is a 10 marker question from this chapter, it is 10 mark. You're going to do the exercise. Put a table. Everyone listen to me very carefully. It's not only for 4 of them. All right. This is applicable to everybody sitting here. Listen to me. This exercise has to be done by everyone sitting here. All right. You are going to do it and I will personally be checking this. How? Don't challenge me. All right. By now you should have at least realized I will do it. At my own comfort, I will do it. Is the screen visible to everyone?
Yes, sir.
Yes, sir.
Yes, sir.
Chapter. Let's suppose audit. All right. Incorporation. FEMA. Whatever chapters are there. Total marks from this chapter out of 100, how many marks were asked from here? Let's suppose 10, 15, 20, whatever it is. How much did I score? All right. Say 10. I've scored only 2. I've scored 10. Find out the percentage. If you have scored less than 20%, that means that chapter requires a lot more of efforts than what you have thought. Am I clear, everyone? Understood? Again, there's a possibility, sir, there might be only one question and only that one topic I didn't read. So there's a possibility that I might be biased. That's why I'm asking you to compare on an overall basis, how much have you lost in that chapter? I'm not asking you to specifically check each topic, all right, or rather each question. Now coming to the next point, how many of you got less than 40? Let's be honest, who cares? Less than 40, we've got. How many of you? Only one person. Not something that I am okay with. 100% no. How many of you have got less than 40? Let's be honest, we are not here to impress anyone. Those of you who were not able to complete the paper, you've still scored more than 40 or what? How many of you have got less than 40? Let's be honest. Start challenging your brain. Your brain doesn't want to take up that chance of looking down and all of that nonsense. Who cares? Shovini, how much did you get?
53.5.
Tanya?
41.
Others? Only one person has got less than 40. Not something that I would be okay with. I'm sure there are people here. Others, one exercise that we are going to do quickly. All right.
Yes, sir.
I want you to go ahead. All right. Immediately after this whole thing is done, I want you to
Yes.
sit, do the same exercise that I've just listed down. Chapter wise, you're going to make a note. I want you to go through the entire answer key once again. All right. I will ask the CAPS team to circulate this answer key. Check where have you lost marks that you're missing out on getting even the minimum, bare minimum. But my point is, you should be more than happy right now that at least you got a chance to correct yourself. This will not cost us anything. This is just going to put us a little extra vacuum to go ahead and put extra efforts towards our studies. Simple as that. All right. Others, I am confident you will get more than 40. All right. You will clear the paper. But my only point is you have to put in efforts for the next 60 days. For all my friends who are stuck between 40 to 60, you are in the danger level. My friend less than 40 is not in danger. My friend more than 70 is at a danger of overconfidence. My friend who is between 40 to 60 is at danger. You will fall below 40 if you don't put in efforts. 40 to 60 is more dangerous than less than 40 because less than 40 has got scared. He will put in efforts and I know he will sail through with the paper. One who is stuck between 40 to 60 is my fear. First reason, you didn't write the entire answer script. Second reason, I'm sure others you would have cleared the paper. I'm sure if you would have finished the paper, but not finishing the paper itself is the first crime which you had done. All right. Second thing, each one of you listen to me very carefully. You will have to put in more than what you thought is an effort for the next coming days. 40 to 60 is a dangerous score. You will any day slip below 40. Sir, so now what should I do, sir? I've already written tests for 1 week. I've studied law. Now I don't even have time. You still have time. Relax. You have 60 days. Something that I have done throughout my CA final journey, because I used to have this one paper called as ISCA. All right. You're lucky that you don't have that right now. All right. I used to have this one paper called as information system. Coming from a finance background, I don't understand chemistry, physics, and I don't understand computers. All right. Of course, it doesn't mean that I can't work on computers. It's just that I don't understand the math behind it. That's why I've pursued commerce. Right. Religiously, trust me, friends, 4 months. 4 months. There was not a single morning from 5 to 7 where I wouldn't have picked that material in my hand and studied. 120 days continuously, 8 chapters. I still remember the number of chapters. All right. It's been more than half a decade since I've cleared. 8 chapters at the tip of my tongue. Whether you like it or not, 84 was my score in that paper. It's not about me. It's about the practice behind which I want each one of you to implement. Guys, if you know you're lacking there, you will have to spend time. Every day religiously, 5 to 7 has to be law. Come what may. I'm studying auditing. I'm studying accounts. I'm studying aeronautical engineering. I don't care. Morning 5 to 7 is only my time with this paper. Am I loud and clear, everyone? Understood? You still have 60 days. 60 into 2 hours, you can still spend 120 hours on a 100 marker paper. Is it sufficient? I am telling you authoritatively, you will be able to cover 2 revisions after this as well. Within one time reading, you will be able to revise as well. Put in efforts. Next 60 days, forget everything else. This is the best time that you have for yourself. And trust me, enjoy the process. Enjoy the process. There are 2 ways. Now, either you sit and crib, cry, sir, it is so tiring, it is so exhausting. It is equally exhausting for me as well. Even I had a session. After that, I'm sitting with you guys. It's a Sunday even for me. It's not easy, but I'm passionate about it. It's fun. It's fun to spend time with each one of you. It's fun because I learn more than each teaching anything. All right. That's exactly how you will have to approach for the next 60 days. Is it tiring? Option A, nahi, study. Am I enjoying? Option A, nahi, study. Everything has to come back to the same book. I know most of you are tired. Stop recording the session, whoever is the co-host.